All right. So good morning, everybody. My name is Monica Rojas. I am the membership and inclusion specialist at Tech Hub South Florida. And today we have two special guests for our Lunch and Learn series. This is more for founders. So if you're a founder out there, you're looking to, have potential conversations with investors or at least confidentiality agreements, this is a talk for you. So I'm going to hand over the mic to David and Stacie, and they can introduce themselves and get started with today's topic, which is NDA talk, protect your secret sauce.
Terrific. Thank you very much, Monica. Stacie and I are both glad to be here. We are attorneys and colleagues at the Gunster law firm in the state of Florida. We're glad to be here. We've been supporters of Palm Beach Tech for a very long time. I wouldn't consider this like a first date topic. Confidentiality agreements are not that fascinating, but we're going to do our best to try to answer questions and anticipate what questions might be and give an overview of confidentiality agreements. Stacie and I are going to divide the presentation up a bit. Stacie, you want to say hello and then I'll come back to me?
Yeah, happy to be here. David and I work very closely together, and we work a lot with businesses and in particular entrepreneurial and technology companies. And it can be from a startup, you literally just organized or incorporated your entity, all the way up into maybe a quote unquote small business with millions and millions of revenue and everywhere in between. So thanks for having us today, and I'll kick it back to you, David.
Sure, thank you. So we're going to first talk about what is a confidentiality agreement. We're going to start real basic. And these are contracts where each party, let me just move the screen over, I'm sorry, one second. These agreements where each party agrees to receive proprietary information from a second party, to use the information only for a specific purpose, and to not disclose the information to a third party. That's as basic as it gets. People don't always treat these as carefully as they should. It's very typical for someone to send over a confidentiality agreement and say, this is our standard agreement, just sign it. We hear from our clients all the time, I just signed the confidentiality agreement, it looked okay to me, or it's just a confidentiality agreement, or it's mutual, or it's standard, or they don't change it. And we don't think that's good practice. You want to treat a confidentiality agreement as carefully as any agreement you would enter into, which at least means read it. Think about what it says, think about the purpose, think about whether or not it's needed and what information you'll be disclosing. With that sort of overall concern in mind, we're going to work our way through the agreement a bit. First, you think about the potential parties to the agreement. Confidentiality agreements can be used for prospective purchasers, for prospective investors in your company, for certain individuals, directors, consultants, executives, for investment bankers or business brokers, for certainly employees. We've seen it done for vendors and for strategic partners. But in each of these cases, you would want to, again, go through the same questions. Do I need a confidentiality agreement? Why do I have one? How can I modify it to make it work? What information needs to be disclosed to each of these parties? I think as an overall, and we'll talk about it a little bit later as well, you don't have to be all encompassing in what's being disclosed, and you can pick and choose. So one thing you want to do is to just talk about what the purpose of the disclosure is going to be. So we like to have a definition of what the sole purpose of the disclosure and the use of the disclosed information will be. So in a transaction context, party A will disclose information to party B, potential buyer, and potential buyer agrees only to use it for purposes of evaluating the transaction or a purchase transaction, not for competing with them, not for anything else. If you're giving it to an employee or a consultant or a director, the purpose is solely for the benefit of the company and not for any other purpose. So in addition to being careful with what the information being disclosed is, you want to be careful of what the purpose of the information is being used for, and to agree on that. Stacie, you, or do I keep going here?
Sure. So continuing what David said, it's important to really define what confidential information is. Because that's where all your confidentiality obligations run to. So you can do a couple of things. You can either have a very broad definition where everything I give to you, whether it's, financial statements, customer lists, et cetera, is confidential, or you could have a very narrow definition, which would be like only financial statements. That's it. That's all the confidential information. If you're the disclosing party, which it sounds like a lot of the founders may be when they're talking out to investors, it's more important for it to be very broad. You want to, anything that you tell the investor you want to be confidential, the investor will certainly try and push back on that, and maybe even not want to enter into a confidentiality agreement. But that's one of the key is how to define it. So here is an example of a very broad definition. It lists everything, and again, it's very favorable to the disclosing party. Here would be an example of a very narrow definition. It's very specific, and then you could even say everything outside of this is not confidential information. One way to maybe bridge the gap is to stagger what you actually give to the investor. So what is necessary to continue the conversation, and have a staggered approach. So I'm not going to give my detailed code on my new software right away. I'm going to explain how it works, maybe do a demo and go step by step. We found that clients have had a lot of success in this staggered approach to disclosing the confidential information, regardless of whether you have an NDA or what it says. That may be the best way to really make sure you have a deal or you're going into a partnership with this person, is to really be thoughtful about what you're sharing and at what time. Going back to the definition of confidential information, another thing to just be careful of, and we've had some clients trip up on this, is in some confidentiality agreements, it will say that you actually have to write on the document confidential, or you have to say before you disclose it that this is confidential. As the disclosing party, you want to avoid doing this because it just, as a practical aspect, you will always forget. We had one client that agreed to this, totally forgot to write confidential on a very important IP issue, totally blew it, and there was an issue, a dispute that we had to get involved in. So if you, as a disclosing party, avoid this. As a receiving party, obviously very beneficial because it's a reminder, hey, don't disclose this. This is confidential. But this is like one of the footfalls that you will see in agreements like this. And the last thing for the definition of confidential information is make sure you have carve-outs for things that become public information, for things that you can do on your own without reference to confidential information, things required by law that you have to disclose, maybe get a court order. These are all very standard and you would expect to see them, and it's just a protecting everybody involved, especially as the receiving party. David?
Okay, what you then want to do as well is in terms of once you've agreed on what the information being disclosed is, then you want to talk about the obligations of each party, not only to keep it confidential themselves, but to cause anybody else they are talking with to keep confidential, as well as not to disclose that you're even having these talks. So for example, if I'm a company and I'm up for sale, I don't want others in the market to know that I'm up for sale. So you would also include a provision in the agreement that says both parties will not reveal that we are having discussions about what we're disclosing information about. And then you also want to be careful if it's too broad. We've seen this a lot, to where a company that's always acquiring businesses in the space or expanding or talking to lots of people and collecting information. So for example, we represented a tech company that was buying a lot of companies that were generating leads for it. And in that context, we're talking to lead generation companies one after another in a very narrow, specific space. And we needed to make sure that in talking to one company in the space, we were in no way prohibiting ourselves from going and talking to other competitors of theirs to try to buy them as well. And we were willing to agree not to disclose that confidential information we received from the one party to anybody else. We wanted to make sure it was very clear that they understood we were pursuing other opportunities, that we were talking to their competitors, and that this agreement itself was not going to restrict that right. Stacey's going to talk in a little bit about how you want to make sure that the agreement is not broader in its restrictions to you besides confidentiality, that you're not unintentionally restricting yourself broader than what you wanted to do.
So a couple other things to be mindful of is what you're required to do, like what are the confidentiality obligations? You see a lot that there's this reasonableness. You have to be reasonable standard of care, and it's very difficult to define that. It's a legal term, but you essentially have no idea what it means. But so oftentimes you will say no less than the way you treat your own confidential information. If you are a founder disclosing information, that may be fine because there's case law and industry standards around that. But if you're very concerned about it, you may want to say that you want the confidential information behind a firewall. Maybe it's password protected. Maybe only so-and-so can see it, or you can only have one copy of it. There's different ways you can define how you treat it, and it will depend on how sensitive the information is. The other thing is you want to make sure that they're required to keep it confidential for the time period you consider appropriate. So as a disclosing party, you may want that to be forever. As a receiving party, you may want that to be for 1 year or some short period of time. One thing as a disclosing party, so maybe the founders may want to consider is having a specific point of contact. So you have one person that's responsible for the confidentiality obligations. This essentially gives some responsibility or ownership to one person to make sure that that's being complied with. So that may be something good to narrow the scope of the disclosure and also put some responsibility on one person's shoulders rather than an organization or a group of people.
And the next thing is after you disclose the information, at some point you may not go forward, or even if you go forward, you may say, I want the confidential information back. So you always want to have a provision in the agreement about what information you're going to return, or they're going to return to you. So we talk about all written confidential information, materials they've created that contain your confidential information. Like in the worst case, you don't want them taking your confidential information, writing it down in their notes, and then only returning your confidential information, but keeping their notes that have your information on it. So you would want them to return that, and any copies or extracts or reproductions they make. And then you want to talk about it, and then you want to clarify, do you want them to destroy it or do you want them to return it? You can go further and ask for a certification from an officer of the company that it's been returned or destroyed. And then in today's world, you need to figure out, what does this really mean for your computer records? So if someone were to email you confidential information, what is your real ability to destroy it? So sometimes you want to carve out that data that is kept on your backup system in the ordinary course of business doesn't have to be destroyed. I mean, that's going to be pretty much impossible to comply with, or very difficult to go through your computer systems to figure out what emails contain the information. So, so very typical. We've seen our clients agree to return all confidential information and then frankly not been able to because of their computer records, or demand something they didn't really expect to have complied with, or the other side says they can't comply with it because it's on their computer records. So you want to know where you'll stand on that. The next thing is when you're giving confidential information out, you want to make sure that you're not making any representations or warranties about the accuracy of it. People are going to be relying on it. So a basic example would be if you're selling the company, initially you're going to give a lot of confidential information to the prospective purchaser or actual purchaser about the company. When you then get down to the purchase and sale agreement, you're going to make representations and warranties about your business. You're going to have lots of limitations on those representations and warranties. You're going to have lots of qualifiers such as, to our knowledge, this is accurate. And you want to make sure that that you can't be sued on information you provided in connection with the confidentiality agreement with the other party holding that you made reps or warranties regarding its accuracy. So just the provision that typically winds up in these agreements.
So while confidentiality agreements are very normal course, and we can talk about how you get to the point to ask for it, but the thing that spooks people is not only the confidentiality obligations, but sometimes, and this is to David's point, it's so important to read the document as you see provisions that you wouldn't expect or a little bit hidden. David sometimes refers to these as a hidden bomb, and these might be non-solicitation obligations, whether it's non-solicit of employees, clients. I've even seen some people bury non-compete obligations in NDAs, which seem really innocuous and normal course. And then you have a non-compete, and in this instance, they were in the same industry, so it was totally inappropriate, and it could have been a real issue if the client didn't read it and send it along to us. But those are things that you should be looking for, things that jump out that go way beyond holding something confidential. Some other things just to pay attention to would be governing law or jurisdiction. I imagine the Tech Hub, a lot of the founders are in Florida. You don't really want to agree to California law and having to go to California if there's a dispute. It's very unfriendly. You'd want it to be here. And then the last thing to think about is what happens if there is a breach, somebody does steal confidential information or use it inappropriately. The remedy is, it's very difficult to figure out what the damages would be. Who knows? There may lost profits, a lot of indirect damages that you can't put a number on. So what you see a lot of times is an injunction where it's a court order, you can't do something or can't use the information. Or sometimes clients will even say, if you breach this, it's $10,000 in what's called liquidated damages. So essentially you agree upfront what the monetary damage would be if you did breach.
So that's our basic rundown of confidentiality agreements. We would agree they are standard. They get entered into often. Unfortunately, they are often signed without being read. As we talked about, you want to be careful about reading them and considering all the terms as if it's a real agreement, which it is. Litigation is very expensive and difficult, and you'd like to try to avoid it. Trying to enforce a confidentiality agreement in reality is probably a minimum of $10,000. It's with no guarantees that you're even going to win or that you can prove they've used your confidential information that you've disclosed. So some of the questions we've seen are, is it typical for investors to sign them? And the answer is no. The reality is what you consider to be your secret idea, you're probably not the only person doing it. Your success is going to largely be based on your team and your ability to carry out your plan. But an investor certainly can't be in the position where they say, I'll sign a confidentiality agreement imposing a restriction on me when I don't even know if I want to invest in your business. So along the lines of what Stacie had described, our recommendation is you stagger information more and more along the way as you get more comfortable to ensure there's actually a reason for you to be disclosing the information. And everyone does not need to know your secret sauce to know if you're a good business or to know what they're looking for. So try to figure out, what exactly do you need? What is it that you need to know from the other side to make a decision to go forward? It may not be their secret information. It may just be you're a vendor and I want to know you've got other good clients. I want to see your client list, or I want to know what websites you've worked on and what code you've written, things like that. That may be confidential. They may want a confidentiality agreement to protect that, but you don't need to get broader than those particular things if that's what you're looking for. At this point, we're happy to open it up for any questions. Monica, if you know questions from the group, or there's people on that have questions, we're glad to answer them.
Yeah, so if if anybody has any questions, please just feel free to drop it in the chat or just take yourself off mute. I did have a question for you guys, and I feel like a lot of founders probably go through this, is where's some affordable resources for early stage founders to create these NDAs or even just get these, like some resources for feedback or review? Does Gunster or any local office, like, do it for free, or is there a website that reviews it?
I'm not aware of websites that would review it. You can certainly find confidentiality agreements online.
Mhm.
They're common enough you could find them. The question is a matter about reading it to make sure that it applies to the way you're trying to use it. So that's going to be the key. I don't think there's law firms out there that I'm aware of that for free will provide the legal services to review and revise a confidentiality agreement. It doesn't take a lot of time. You should be able to find a lawyer, hopefully that's working on your team, that can do it quickly. And again, you should be able to find the base of those agreements available.
Right. Okay, and I did also have another question. We talked about mostly investors, but what about when you're, doing your first employees and or even just outsourcing certain, projects? How do you go about, or what should be included when you're doing that, when you're working with not investors, but people that could be, in the inside?
I think that's a different discussion. I think in those situations, you can certainly be more forceful about asking for an NDA, and you should. I think that depending on what your business is, you may want to consider asking for more than just an NDA, right? Like if you're hiring someone that's going to be writing code or creating some sort of IP, you should have what's called a work for hire provision, which essentially says that anything you do for the company will own it. And that's the same whether it's an employee or a contractor. But I think the discussion is different with someone like that than an investor, where you may not be able to get an NDA. I think with those people, where you're paying them, you should always do this up front, because that's when you'll have your most leverage. But you should certainly get those at that juncture.
I agree, for sure.
Right. And then I did have a question. You guys work with a lot of startup founders. What are some of the mistakes that you guys see constantly, and how can we address them?
Stacie, you want to take it?
With respect to confidentiality, Monica, or
Yeah.
even within that?
Well, just agreements, like what, do they say too much? Do they not do it in the right time? Certain things like that.
I think one thing that I see is that they don't really know, I guess, how to go about sharing the information. They either share too much, right? Like they just go on and share too much, whether that's their IP or not, or they like, or spook the deal because they're too concerned about it. Like they don't want to do anything without an NDA, and it's so I think the staggered approach that we keep talking about is so important, and just being thoughtful. I mean, we're working on a deal right now where we're past the LOI and into negotiating the purchase price. So we're very far along in the dance trying to get a deal done, and we still have information that we haven't shared, and that's because we've had this thoughtful approach. At the most sensitive IP, we're going to wait until we're sure that every deal point is covered. So it's I guess being too far on either side of the spectrum, oversharing without having the protections in place, and then being too cautious because it's, things move. I understand things move quickly, and you not always have the legal buttoned up, but blowing a deal because they're too concerned about it.
Right.
Yeah,
Okay.
and I think one of the points that we keep mentioning is that people don't treat them as real contracts. So it's almost the people that sign these like you would a disclaimer when you go horseback riding or something, thinking that you can't change anything. It's just a form. It's standard. I'm just going to sign it. Are making a mistake. And as you grow, and as a company, at some point in connection with due diligence, someone's going to say to you, give me a copy of all the confidentiality agreements you've signed. And you're going to have to go back and look at those. And the bomb we talked about, having some restriction in there that is problematic, is going to cause you great heartburn. So you've got to treat these like agreements, and they're not terrible. You just have to read them and be thoughtful about it. That's really it.
Right. And have you guys seen that happen a lot?
We've certainly seen people not take these seriously. Yes,
Mhm.
that's very common. And look, and it's understandable. It's a combination of not understanding it, and it's not, entrepreneurs are not lawyers for the most part, so they don't want to read it, care about reading it. B, lawyers are expensive, obviously, and that you don't have the money as a startup to pay a lawyer to review it. But that's why you come to a lunch and learn like this,
Mhm.
and at least get a little bit dangerous learning what to look for and what to be aware of. And with this in mind, look, if you attend a seminar like this and you pay attention to it, you would hope that 80%, 90% of the confidentiality agreements that are stuck in front of you, you're able to read them and make sense out of it and come up with a thoughtful approach of how to address it.
Right.
And the 10% that are really funky, you can either say no to, or here's our own form, or that's the time you call your lawyer and get a quick answer to a question about it.
Right. And that makes sense. And Tony, I know Tony, he has a startup as well. Tony, if you have any questions for David, just feel free to take yourself off mute. Mike and Catherine, Mike, you brought up some good points earlier as well.
I guess we did a great
Hi,
job of
everyone.
answering
This
all
is
the
Tony.
questions.
Can you guys hear me?
Yeah.
Just trying to walk away from the baby. Hi, everyone. I joined a little bit late, but I don't necessarily have a direct question. I just kind of wanted to be a fly on the wall and hear it out. My particular situation is I offer consulting services to various companies, Fortune 500 all the way down. So they being the client or even a third party or recruiter might put an NDA in front of me and say, hey, sign this if you want this job. So that's why I'm just kind of fly on the wall just to hear the discussion. I do try to stay away from NDAs as much as possible, just because it complicates things and I don't have a lifeline to a set lawyer all the time. So
Sure.
usually it's a recruiter, meaning they reach out to me and they have the client contact and they want me to provide services to that client. They'll say, sign this NDA in the process. Sometimes I do, sometimes I don't, but it's very finite. I would say, hey, I'll sign it, but it's only 6 months, only in a year. Like it's not forever. That's kind of how I cover myself. So anyway, that's kind of what I do. And then when I work with a third party, maybe company X has a new software, they want me to provide certain services, they might put an NDA in front of me, but that hasn't happened that much. So, that's kind of my background. I don't know if that,
Right.
if you two have, any insight or advice for me, but that's my realm.
Well, it sounds like you're doing the exact right thing. I mean, if you have to sign it, you've got to sign it at the same time. You're at least reading it and making sure that you're comfortable with complying with its terms.
Yeah,
So,
and I just like to always time box it, right? So if I can reduce, months rather than years, I'll do that on purpose.
Very good point. That's the way to do it.
Yeah, it sounds like the definition of confidential information, how broad is it? The term is important. And then, as I mentioned, just be wary of those hidden bombs. Like someone says you can't provide services to anybody that competes with that client, right? Like you don't want to be restricted on that. So I would just be wary of those type of terms: solicit, compete, things that don't seem to belong there.
Gotcha. Thanks.
Yep, agreed.
And then Mike has a question in the chat. I guess the only other question, when is it good to avoid NDAs? Any best practices? It's a good question.
As the person receiving information,
Probably as a founder.
as a founder,
Yeah.
I would avoid, if you're not sharing anything confidential, I would avoid it. Like if it's not something that isn't already out there or isn't something that's really important and key to the business, I would avoid it. Because anytime there's a confidential information, you just open the door for someone to have a claim or dispute about something. But as you start getting towards you're sharing your confidential information as a founder, you just ask the question to yourself, like, am I getting to that point where I need an NDA? as a founder, if you're the one receiving information, you don't want to have the NDA. So as a receiving party, you always try and avoid it, as Tony kind of mentioned. As a disclosing party, I think it's like a sliding scale. As soon as you start moving closer and closer to confidential information, where it's kind of like a spidey sense, like am I getting uncomfortable that this is getting closer to that side of the scale. Do you have anything else to
Yeah,
add?
no, agreed. I think that's very good, Stacie. Yeah, I think you've nailed it. And that spidey sense is a good indicator for any agreement. You know, when you're
Mhm.
reading it and there's a question that you have that you're not comfortable with, that's the time to double check, get a gut check on it, make sure it's fine.
Yeah, awesome. No, I like that spidey senses too. That was a good reference. Something that we could all kind of relate to. But yeah, I mean, if nobody has any more, final questions, or David and Stacie, do you guys have any final words? Awesome.
Nope, I think that's it.
And Ali applaud. All right, so I can go ahead and end it early. We do want to do something in the future with more open conversations. Maybe we can pull you guys into our Startup Founders peer group. We have those once a month, every Thursday, and those are always just, organic questions and, our founders giving each other advice. So we would love to have you guys there one day so we can talk further about that.
Awesome.
But yeah, no, I appreciate your guys' time. David and Stacie, or David, it's nice to
Great doing
see you. Stacie, it's nice to meet you. And everybody else, thank you for attending. This will be on YouTube, so feel free to share it out and help some other entrepreneurs.
Awesome. Thank you very much.
Monica.
Thank you.
Awesome, guys. Have a
Thank
great
you.
day.
You
Thanks,
too.
everyone.
Bye.
Bye-bye.
Thank you.